Now, the court, I think, has put the cart before the horse. And in one sense, they're right because, like the petitioners asked them, they really couldn't read into the Special Marriage Act in a way that could both save its validity and make it gender neutral. It was simply not permissible for the court to do. But I do think that there is a prior question which the court should have answered in the affirmative, which is that there is a fundamental right to marry as part of the right to personal liberty under the Constitution.
I'm sure calling the Constitution colonial would have led to some backlash for you.
There's a quote that has sometimes been attributed to Gandhiji that first they'll laugh at you, then they'll ridicule you, then they'll try to fight you, but ultimately you will win. Uh, I believe that in the Constitution, the state towers over the citizen. There is a large state that is envisaged by the Constitution, and this is a continuation of colonial institutions.
What were the alternatives that they had at that
Said that
time?
the lawyer without a knowledge of history is like a mechanic and not a very good one at that. So, if we don't understand history, then all we are doing is that we are trying to be clever with words, right?
How and why do you think those Gandhian principles are missing from the text of our Constitution?
Drafting committee didn't spend much time behind bars. So perhaps that is the perspective from which they came from. But so the fact is that amongst the Constituent Assembly, a large number of members were holding critical executive positions. And so they may not have been able to give this as much time as was necessary. As in our politics over the course of the last 70 years has meant that there has been a sea change in the way in which Baba Sahib has been viewed. At the time when Baba Sahib became a member of the Constituent Assembly, he was a politician who had been brought in by the Congress party because he didn't win, he didn't get elected from the state of Bombay. He then went over to Bengal, where Jogendranath Mandal, another very fascinating leader who became the law minister of Pakistan first, but then was quite bitter about it. And I think Ambedkar himself might have been fairly distraught that he has become a little bit of a holy cow, and it's not possible to have a discussion on his works without an allegation that you're disrespecting him. I hope to do that in my book by saying that I respect Baba Saheb wholly, and a lot of what he has done in the constitution is why uh, India is in such a great place today.
Hello, everyone. Welcome to the first episode of the Basic Structure Talks, where I speak with legal experts on their interesting work, topical issues of constitutional law, and other allied areas. The idea behind this podcast, much like the blog, is to summarize, simplify, and explain the law for both lawyers and non-lawyers alike. Therefore, I hope to keep the spirit of the blog alive and spare you from the heavy legalese in these conversations. For the first episode, I am delighted to have Dr. Arghya Sengupta with me, who is the research director at the Vidhi Centre for Legal Policy. Dr. Sengupta is the author of several academic books and has written constantly on the courts and the Constitution. Dr. Sengupta has come out with a fascinating book titled The Colonial Constitution, published by Juggernaut. He explains the book as, and I quote, "The story of why a group of freedom-loving Indians who, having liberated themselves after 2 centuries of colonial rule, chose to compose this so-called music of an English band and call it the Constitution of India." I have already reviewed the book on my blog, and I'm sharing a link in the description below. Enjoy the conversation. There is a lot to learn, and most importantly, a lot to unlearn. Thank you so much. Enjoy. The year is 2000. The Supreme Court is celebrating a function to commemorate 50 years of the Constitution of India. The gathering is August, and everyone, including President K.R. Narayanan, England's Lord Bingham, is praising the Constitution and proudly recalling its ties with the British traditions and practice. It is a mutual love fest. These are not my words, but the words of Dr. Arghya Sengupta, who sees this as proof that our colonial masters may have returned to England, but colonial rule has not. These observations are interesting because, as a student of law in India, one is taught to venerate and worship the Constitution. It is supposed to be the nation's holy book. And here we have Dr. Sengupta calling it colonial in his new book titled The Colonial Constitution. This is the book. What is the basis of this claim is something we will explore in this episode today. Thank you, Dr. Sengupta, for agreeing to speak with me about your fascinating book. Should I call you Dr. Sengupta or should I refer to you as Orgo? What would you prefer?
Please call me Orgo, and thanks very much, Swapnil, for having me.
To the viewers, I must confess that previously I have worked with Orgo at Vidhi. However, my association and loyalty would not come in the way of the questions I asked today. That is a promise.
I would certainly hope not.
Uh, Before moving to the book, Orgo, I believe I would be doing injustice to everyone watching if I didn't ask your thoughts on the recent judgment delivered by the Supreme Court in the marriage equality case. The court, by a 3-2 verdict, has refused to recognize queer marriages or even civil unions, which are akin to marriage. What are your first thoughts on reading the judgment?
Yeah, so first up, I think, Swapnil, this is a really good time to be discussing the issue of a colonial constitution as well, in light of this judgment. The I am a person who has always said that the courts should be restrained and the courts should have deference to the executive and the elected legislators for questions that they have neither legitimacy nor competence over. Now, but there is a fine line between deference and dereliction. And my view is that there were two aspects to this marriage equality case. The first is as to whether there is a fundamental right to marry in the Constitution. And the second is that how will that right, of whatever kind, whether it is to a marriage or to a civil union, if that were indeed an option, how is that going to be effectuated and can the courts do that? Now, the court, I think, has put the cart before the horse. And in one sense, they're right because, like the petitioners asked them, they really couldn't read into the Special Marriage Act in a way that could both save its validity and make it gender neutral. It was simply not permissible for the court to do. And so some of the remedies that were being asked for in terms of the Special Marriage Act being read in a gender neutral manner, it's simply beyond the court's legitimacy to do that. And for that, Parliament was the right forum. But I do think that there is a prior question which the court should have answered in the affirmative, which is that there is a fundamental right to marry as part of the right to personal liberty under the Constitution. It is my view that marriage is a fundamental unit of family life in India. It is something that while we can talk about typical families of many kinds, and I'm sure, I mean, no disrespect to any of them, but the fact is that marriage is the fundamental unit of family life in this country, whether it is heterosexual marriages or homosexual marriages. And I'm not saying that you declare the right to have a homosexual marriage part of Article 21. I'm simply saying that everyone should have a fundamental right to marry. By everyone, I mean every adult should have a fundamental right to marry under the Constitution. And I think the court could have made that declaration and could have stopped there, and the rest of it leave it for Parliament to legislate. And so fundamentally, that part of Justice Bhatt's opinion, which is talking about why he can't read in that right, it really doesn't make much sense as a matter of logic, because he says that it entails positive obligations. And but so do a number of rights that have been read in, including the right to privacy that was read in. The fact is that positive obligations are now, as in even in the theoretical literature, which you would certainly have read, every right as in has both negative and positive obligations. As in there is a right, as in if somebody has a right, then there is a duty not only to restrain, but there is also a duty to uphold or a positive duty to protect. All these exist. So my sense is that this is a missed opportunity, but this actually, and coming back to my book, is the reason why we should have asked this question, that what kind of constitution do we have which is giving the judiciary the leeway to take these kinds of calls? And I think that's the discussion that is imperative.
Definitely, I certainly agree with you. And I also felt that I wasn't convinced on why they have not given in a constitutional status. But I was reading a lot of literature around the judgment since it's out there. There's a few of it. And people were also very critical of the fact that why has the court used this principle of separation of powers, which is very conveniently invokes and refused to lay down policy. And
Yeah,
we've
you see, and I think that that's the sorry to interrupt you, but this actually really gets me excited because the issue is that, had this not been the Supreme Court of India, I think these kinds of arguments around separation of powers may have received a greater degree of credence. But the Supreme Court of India has expanded its jurisdiction so much over the course of the last 30 years, whether it is deciding whether who will run cricket administration in the country, whether it is deciding as to where liquor vends will be located near the highway, whether diesel cars should be allowed to ply or not. Now, these are questions which are not in the judicial domain at all. So, for an institution that has paid scant regard to this, to suddenly turn around and say separation of powers when actually this is a 50-50 case, that's what I think has really irked.
No, definitely. I agree with you because I remember when I did a review of it, that's what people said, that it's just a convenient tool and you don't want to intervene, that the courts will just come up with something like this. I remember in your writings, you've constantly maintained that you are somebody who really trusts the democratic process. And I think when Vidhi came out with the model code on marriage reform, I think that was one example of it, that you do recognize marriage equality and the code has done it. What do you think should be the next steps the government, particularly both the central and state government, because marriage is a concurrent list subject, that they should do to recognize queer rights and queer marriages? What do you think should be the steps ahead for the government?
See, I'll be perfectly frank. I have followed this debate as an outsider for the last 15 odd years, not longer than that. But as Arvind Narayan was saying recently on a TV show, that the fight for Navtej took 17 years from the time it started. And marriage equality would likely take longer because you're actually looking for uh, something that is changing an existing institution and not just decriminalizing something that shouldn't have been criminal in the first place. So, my sense is, and I know that this might be provocative to some, is that this case was filed in a slightly premature manner. And I think that this is something that the judges weren't ready for, that society isn't maybe fully ready for. And so it is something that, though it may seem like a dark day, I think in some sense it is a silver lining that the both the LGBT community as well as sympathetic people must ensure that there is greater public acceptance of this, of marriage equality. And at that point of time, I am confident that parliamentarians and legislators will be able to see reasons. So, of course, in the short term, there is this committee that has been set up, or will be set up under the cabinet secretary, as the government of India has said. And one can certainly hope that that committee will look into this issue uh, with the seriousness that it deserves, and will try and make sure that there is ease of living for persons who may be in relationships that are not recognized as marriage. So whether it is in terms of bank accounts or ration cards or any other kind of documentation, I hope that the ease of living for such persons will be worked out by the committee. Second, state governments and state governments that are sympathetic can also take a look at this issue. There is nothing that precludes them from looking at marriage laws on their own. So there is absolutely nothing that stops a state government from saying that in that state, persons of the same gender will be allowed to marry each other. So I think that's the second thing that needs to be done. And the third thing that needs to be done is overall greater mainstream advocacy. I think for a long time, particularly within the LGBT community, there has been a lot of really sincere advocacy that's been done. But my sense is that a lot of it is in the circles that you and I are in amongst law schools, amongst universities, and a lot of us are anyway already largely sympathetic to the cause. I think that there is now a need, as yesterday in an article Anish Gawande had written, and I agree with him entirely, um, that this is really a time to generate greater public discussion and greater public acceptance so that mindsets can change. And I am confident of the innate liberality of Indian people. I think that the Indian masses are innately liberal and will live and let live. And I think that we need to get rid of some of this baggage, particularly on issues such as homosexuality, which I can safely say is colonial. This baggage is something that we need to get rid of.
I think that response is a very good segue to the question of moving to your book, because I remember I was reading the judgment, and Chief Justice Chandrachud, in his opinion, highlights that our society's uncomfortable attitude towards the queer community is actually a product of British colonialism. And earlier, India was accepting of the queer community, and they were part of the society, much like everyone else. So, here the court is touching upon the colonial influence on our laws and society, which brings me to the book you've written, which is the Colonial Constitution. Now, before I delve into the book, I'm sure calling the Constitution colonial would have led to some backlash for you. I remember the day when you released the book cover on Twitter, there was a lot of activity. I must ask you before I move into the merits of the book, how do you deal with such criticism and bitterness of putting your work out there, because you're putting it for everybody to judge and people have different opinions on it?
Yeah, so Swapnil, there's a quote that has sometimes been attributed to Gandhiji, that first they'll laugh at you, then they'll ridicule you, then they'll try to fight you, but ultimately you will win. So the fact is that if there is opposition, I take that only as a fact that I have been able to move people into thinking for themselves. And once they get over that initial reaction, if they sit down and think about it honestly, then I hope that they will see some merit in what I'm saying. So the so whether it, and I'm particularly on social media, I don't give much credence to too much backlash on social media, because in my experience, as in of the if there are 10 people who criticize on social media, I maybe at most one person will be able to come and say that on my face. Nine people will not be able to do it. So I actually don't give much weight to this kind of armchair criticism, and but there are always some genuine points, and I think that always gives me room for introspection on how I can do better in terms of my writing and my ability to persuade somebody who perhaps holds a different point of view to begin with. So yeah, so I think it's part of life on Twitter, and you have to deal with it.
Yeah, I particularly ask this question because when I speak to law students who are just venturing into legal writing, they're not prepared for the backlash. So it's really helpful to know someone who's done it and know that it's just a part of the process and you
See,
don't
I
have to
think
take it too.
ultimately you must believe in yourself.
Yeah.
It's that is really the key, because if you don't believe in yourself, that's when the backlash will start affecting you, because then you'll feel like, why have I got this backlash? But if you are getting backlash for something that you truly believe in, then you will fight your cause, right?
Yeah.
And so the only thing, as in, given we are having a candid conversation, the only thing that I would have done much more of if left to myself is that I would have responded more to people on Twitter, people who
Yeah.
are abusing. I would have responded more,
Yeah.
saying that, trying to make them see reason. But I've realized much the hard way that perhaps Twitter itself is not the best forum for having a civil discussion on issues, because there is a lot of posturing that's going on for the galleries, and it doesn't seem to be a forum for much discussion. Not to say that no discussion is possible; it's not a notice board. But my sense is that if you believe in what you say, everyone need not agree with you, but it's your view, and you should back it. So if someone is opposing it, fair enough, that's their view, but you should stick strong to your view and not let it affect
Perfect. I think that's a very helpful response also. Coming to the book, particularly I wanted to start with the title. So you've used the term colonial for the Constitution. How do you define the term colonial or coloniality in the context of your book? Because I think that will really help set the context of what background it's written on.
Yeah, that's right. And it's good that you asked this, because as anyone who has read my book will know that this is not an academic book. So I didn't have the liberty to go into academic definitions of what I mean by colonial. That would have made the book an unreadable one. But how I see colonial as is four ways. Number one, it's colonial because of the fact that it is an overly prescriptive document. The reason as to why this constitution is so long is because of the fact that the constitution framers did not want to trust people who they felt were not ready for democracy. Now, I'm not going into the merits of right or wrong, but this is a holdover from the colonial construct of the natives can't be trusted. Okay, which is why we have such painstaking detail in the constitution. Number one. Number two, it is written in English, it is with a copy in Hindi, but and it is a dense legal jargon. Okay, so if you were to really be drafting a document that citizens can understand, one, I mean, immediately that document should have been in multiple Indian languages, and two, that document should have been in simple language, whichever language it is that we were writing it. That's the second reason. The more theoretical reasons are, one, I believe that in the constitution, the state towers over the citizen. There is a large state that is envisaged by the constitution, and this is a continuation of colonial institutions. So, for example, if we were to write a constitution for India, and we think that, the general middle class sentiment, we don't like the police are corrupt, I don't want to go near a police station, so maybe if we were to write a constitution today, we won't have the police service in this way. We would think very differently. And the constitution framers had that opportunity because the imperial police service was responsible single-handedly for the brutality of the British Raj. But the fact is, not only did they choose to continue the imperial police service, they renamed it the Indian Police Service, and they also enshrined it in Article 312 of the Constitution as an all India service. So the fact is that we continued colonial institutions because we believed that now that they would be run by Indians, they would be run for Indians. But that is has turned out not to be the case because matters regarding how human beings think and act towards each other is a little bit more complex. And so, number three is that we have a state that towers over the citizen and that perpetuates colonial institutions. And number four is that I do feel, and this may be necessary, and I'm not for a moment doubting the necessity, and maybe and in this case sometimes I feel like it's not meant to be wholly pejorative saying something is colonial, that this is a law and order constitution. We have very wide powers given to the state to preventively detain individuals. We have extremely wide restrictions on rights that are provided, and even attempts to limit that, such as, we know the famous debate on Article 21 with due process, and due process not being used, but procedure established by law being used, are all attempts to make sure that the state has power. And the reason that is the case is a belief that now that we are independent, the state will not be the oppressor, but the state will be the guarantor of liberties. But that's never the case. The state is never the guarantor of liberties. The state is always antithetical to the citizen. And how do we ensure a more uh, cordial relationship or even a more amiable relationship? And that, I think, is through some omissions in the constitution. That is the idea of a duty. What is the duty of a state? What is the duty of a citizen towards each other? I think that's one big fundamental idea that's lost. And number two is greater emphasis on what India needed at that point of time. So India needed, as the framers of the constitution kept saying, India needed every citizen to be educated. But the debate around education becomes a very legalistic debate on justiciability, as to whether the right to education should be justiciable. There wasn't really much free form original thinking around education and how to make the country educated. I only use this as an example. So these are four positive reasons as to why I think it's colonial, and two omissions of duties and what we now call socio-economic rights, as to why I think there wasn't enough original in the constitution.
Yeah, I think that's a lot to unpack, and we'll slowly do that in the next set of questions. But I do agree with you. I even remember reading that the assembly members had to do a lot of efforts to even get the constitution translated to Hindi, and that's why I think one of the arguments why Republic Day got pushed to 26th January and all of that. And I believe since our childhood we've been taught that the constitution being the longest is a good thing, but once you start studying the law, you realize that's not necessarily a good thing because
Yeah, you know what? You think about it, and why is it a good thing? I mean, if you even want to ask the question, and I used to think, when my school teacher used to say it, that why is it a good thing? And I wasn't sure because I just felt very proud. I felt very proud about the fact that we had the longest constitution. And it upsets me. What I am saying upsets some part of me. Okay, because I still feel that I want to hold on to that. It is the longest constitution, something we are proud of. But we must ask ourselves these questions. And we can have a beautiful constitution that is not long as well, and a beautiful constitution that is long. But I think we
Yeah.
need to ask ourselves the question as to why we have the longest constitution.
Before moving to the substantive of the overview you just gave, since a lot of people who might be watching this are law students and people generally interested in politics and the law, your book heavily relies on the Constituent Assembly debates to understand forgotten arguments, notes of dissent, and the thinking of the assembly in general. Now, for anybody who's interested in the law politics of a country, how important are these debates and why should we read them and not leave them forgotten? Because I ask this because Constituent Assembly debates in law school were conveniently invoked in projects or someplace where when you wanted an argument to support you, you'd ignore the others and you just cherry pick. But why do you think it's important for one to engage with this rich literature of debates that we have in the assembly?
Yeah, I'm very happy you asked this question, and I'm also very happy that at least they were conveniently invoked at the time when you were in law school, because in the time when we were in law school, we actually hardly even knew about them. Okay, so it was there somewhere. Those five green volumes were there in the library somewhere, but we hardly ever used them. And I think the reason as to why I actually discovered the importance. Sorry, before I come to the reason, I actually discovered their importance when I was doing my masters in Oxford. Where not only did I discover the volumes in their fullest detail, but also Shiva Rao's framing of India's constitution in six volumes, which is the most wonderful piece of work on legal history and the process of drafting the constitution that goes well beyond the Constituent Assembly debates. It starts much earlier. So, having said that, why do I think it's important? I think I go back to what Lord Bingham had said. Since you mentioned Lord Bingham in the beginning, he quoted from Ivanhoe, and he said that the lawyer without a knowledge of history is like a mechanic, and not a very good one at that. So, if we don't understand history, then all we are doing is that we are trying to be clever with words, right? But that's not who a real lawyer is. A real lawyer must understand as to what the provenance of a particular provision is. Where has it come from? Why did it come? What were the discussions that happened at that time? And only then can you understand as to whether that how that provision should be constructed. Okay. Now, I don't want to get into the debate as to whether, there's a big debate in the UK about parliamentary debates and how much they can be introduced. And there's a judgment of the House of Lords in Pepper versus Hart in terms of the relevance of parliamentary debates to constitutional and judicial argument. But in India, we have happily said that we can use Constituent Assembly debates as aids to construction and also legislative debates. So that's a good thing. And so the reason we need to know it is because we need to know our history. And it is so fascinating because one, it kind of busts this myth that you know and that the constitution framers were some kind of golden generation, and it's been terrible after that. You see the same kinds of prejudices that people have today. You see a lot of atrocious things being said in the Constituent Assembly, people holding some really prejudiced views on various matters. Number one. Number two, you also see a sense of common purpose. You see a sense of common purpose in wanting to uh, ensure India prospers. There are, of course, different ways of doing that. So I think it needs to be read by each and every law student because we must know where we come from as a legal culture. Number one. Number two, we must read them because they just make for very nice reading.
Absolutely. I remember you mentioned that it shows that people were the same. I remember reading a debate where a member had moved for an amendment to the Constitution to recognize rights of men against women, which I was very fascinated by, that something like this could even be debated. So I absolutely agree with you. And I think for somebody who loves legal history as much as I do, your book is an absolute treat. And I'll come to that bit so because there is so much legal history to unpack. But coming to the central argument of your book, that is the Constituent Assembly borrowed heavily from the Government of India Act, which is a legislation which the members had once denounced themselves, which they didn't think was a good legislation which we need to adopt. And they've now retained colonial structures and provisions. However, my question would be, when you have a large and diverse country like India, and the structure, of course, produces a very towering state, do you not need such a towering state to govern a country as large as India? And point number two, that often the provisions that you've spoken about, like provisions on emergency, provisions of preventive detentions, these are provisions that are not just unique to India. Every country that's like a large country incorporates them because it thinks that they're necessary to govern a large country, especially like India. So, how would you respond that they're necessary for a country?
Yeah. So I think there are two things. One is that it is a perfectly legitimate choice to say that we need a large state at a time of internal strife. As I recognize in my book, there was partition, there were bloody riots happening at that time. So the need for empowering the state is well understood. Okay, number one. Number two is that, however, we need to not ask this question as to whether there was a need to empower the state or not. I think that's a simplistic question. But the question always is one of balance, because you know that India is a diverse country and now it needs to be held together by a strong center. But you also know that if there is a center that becomes too strong at some point of time, then that too creates its problems at the margins, right? So, too much disunity as well as too much unity or too much unification can also be a problem. So the question is always about striking that right balance. So did we need a state that was powerful? Yes, we needed a state that was powerful. But did we need a state that needed to preventively detain people for all times to come? Maybe not. Because the fact is that the constitution framers knew that they were not drafting an ordinary law. If it was an ordinary law to give ourselves emergency powers for a period of time, then why is it that Article 356 was not there for a short period of time? The idea of time limits on provisions in the Constitution is very well known, whether it be reservation or the right to education. We've had time limits, but there was no time limit on emergency provisions. There was no time limit for preventive detention. So even if we felt that we needed these things, I felt like these could have been temporary expedients, because once you keep these things in, you know that they are going to be very hard to remove, right? And you are, after all, writing a constitution. So that's the first thing. The second thing is that the fact that we needed a strong state didn't mean that we needed to borrow that state from the Government of India Act. The fact is that that was a colonial state, and it was a colonial state factually. The idea was to perpetuate the colonial rule in India. The and so the thing is that I think the constitution framers were optimistic at that point of time that now that the British would leave, as in the colonial mentality would leave with them, but change doesn't happen so quickly. But the moment of drafting the constitution was a real moment of change. We had just won our freedom. It was a time when whatever they did would have been largely acceptable because Pakistan had gone its own way. So there was a large amount of consensus in politics at that point of time. So I think if ever there was a time and chance to change things and even to make it a little bit more radical and different, and perhaps think for ourselves about the governance mechanisms that was needed, it was that time. So even if we wanted a strong state, it should have been our state. And I just think that we continued a state that was not our state and hoped that it would change. And unfortunately, it has.
Do you think that was a conscious decision, that they felt that let's go with tried and tested mechanisms rather than
Yeah.
explore something new?
It's interesting because Sandipto Dasgupta has a very interesting article in Udit Bhatia's volume on the Indian Constitution. And he's arguing broadly, and I'm paraphrasing, that the Constitution was neither a document of continuity nor was it a break from the past. Okay. And I think there's a lot of truth to that. And in some places, they break from the past, as in whether it is equal citizenship or universal adult franchise and so on. But in some places, they don't break from the past at all. And Sandipto's words are, and I quite like what he has said, that the constitution, it feels, has been drafted from the point of view of the anxious administrator, is what he calls it. Okay, and it does seem like that, right? You're always worried that someone will come up, someone will do something. That's and the anxious administrator is usually nothing but a colonial administrator whose job is to ensure that there is no uprising or there is no revolt of some kind that happens. So my sense is that this is actually the way in which to see the constitution, that the constitution is not a kind of founding moment. that suddenly springs out of the ether and becomes the beginning of India. I think that's a very convenient reading. It makes us feel very good about ourselves. I really want to believe that, as much as I like Madhav. But the point is that I genuinely feel that that is not the reading that has the greatest backing of text. Sandipto's reading, that it came as in a continuum. In some places, it continued from the past. In some places, it was trying to break. I think that's truer because the constitution framers were conscious. They were conscious of the fact that they were not departing because they wanted stability, and it is there in multiple places in the assembly debates.
Also, I mean, you touched upon the fact that we often cite our equality code as one of the reasons that makes our constitution so unique. So we have some unique rights like right against untouchability, the prohibition of begar, and then right to equality, prohibition of discrimination, others, which might not have been present in other colonies when they got their constitution. And that's often cited as a reason that, see, that's why our constitution is Indian. We might have borrowed structures, but these provisions make us Indian. And I think you briefly do touch upon this in your book. But how would you respond to such an argument that says, look at our part 3, which is the soul of the constitution, as Article 32, as Dr. Ambedkar talks about? So doesn't that kind of trump this argument that, see, we do have a lot of Indian provisions as well?
Yeah, see, I actually genuinely don't think that. I mean, we could Indianize some colonial provisions as well. So I'm just naturally uncomfortable with binaries of all kinds. But is there a lot of our genius in the Constitution? Yes, of course there is. Okay, and so when I say that the Constitution is colonial, I am not saying, and here I'm donning an academic hat, that the Constitution is wholly colonial. I mean, there's nothing in it that is Indian at all. Okay, I mean that has never been my claim. And someone else on the other side cannot say honestly, and this was one of the Twitter debates, that the Constitution is not colonial at all. And that would be lying for Twitter if somebody did that, right? And that the Constitution is, this genius of the Indian mind that has decisively broken from the past. It is not that as well. Okay, that actually might have been said about the America parts of the American Constitution at the time that it was being drafted, that there is something genuinely original about that kind of checks and balances model, which was not present at that point of time. But it cannot be said about the Indian Constitution, because I love my country and I love my Constitution, but we have to call a fact a fact. And so I think that part three exists, and part three, and I'm glad that part three exists. But the question is really not about whether part three exists. Of course, part three exists, but the question is really that what is the balance that we are striking in part three between the rights of individuals and the restrictions on those particular rights. And I think, as you said, you talked about the equality code, and it's interesting because it did finally come into the constitution and in part three. But when it started off as a directive principle. So the journey of Article 14 is actually interesting, because if you see the first subcommittee of fundamental rights, that subcommittee had recommended equality as what we now know as a directive or a non-justiciable principle. Okay, and it was only after the advisory committee that equality came into the justiciable parts of the fundamental rights chapter. Education, on the other hand, was in the justiciable part and then moved to the non-justiciable part. Okay, so the point is that there is a lot that is genuinely based on our lived experience, and I certainly think that's worth celebrating. And the thing that you mentioned and you briefly touched upon, and I have written in my book as well, in my chapter on Ambedkar, is that because of Ambedkar's presence, the one issue that is genuinely uh, based on our felt experiences is the issue relating to caste discrimination, reservation, and untouchability. These are original provisions. These are provisions that were needed in India at that point of time, and I would have just liked to see, like caste discrimination was tackled so sensitively by Baba Saheb. I would like to see that there were many such other issues that were based on our lived realities: our need for better health care, our need for better education, our need to ensure prevent religious discrimination. I think all these issues might have had more time of day as well in part three.
Fair enough. And I think you also mentioned Dr. Ambedkar, who I remember, as you write in your book, had said that there can't be anything new in a constitution at this hour. That's why they justified that we went around and we picked some different provisions. But my follow-up
But that
question,
statement actually, sorry, Swapnil, because
yeah,
that statement actually was very revealing to me. Because here is a man who is an intellectual. Okay, you read him and you realize that he is an intellectual. And here is a man that shows how deeply colonized our mindset is. That we think that there is nothing original at this point of time because constitutions have been written for 200 years. Yes, sure, we must take the best from everywhere, but the fact is that there is our lived experience, not just of 200 years of constitution writing, but 2,500 years of various practices which have existed in this country in terms of governance mechanisms, in terms of social customs, and in terms of practices of culture of a cultural nature. And these things have existed over a period of time. But it just showed that, and Baba Saheb by no means was alone in this. This was largely the view of the whole Constituent Assembly, that with some exceptions here and there, that we need to look abroad, we need to look elsewhere because these are countries that have made it and we haven't. So it was just the product of the thinking of their time. They wanted to do what was best for India, and they felt that looking abroad was what was best for India. I just think 75 years down the line, we need to rethink that.
and I think all of them came with their own set of backgrounds and experiences. Like, for instance, from my limited reading on Dr. Ambedkar, he had a very US based education. So his draft of the Constitution was modeled a lot on, his first draft was modeled a lot on how the US works. That's why I think he called it the United States of India. He used a similar terminology. When the question was before the assembly, what were the alternatives that they had at that time? What could have been the alternative structure that they adopted? Now, from
Yeah.
after reading the book, I felt that you do touch upon a lot of them, but then you also criticize it. Listen, this was the problem with these structures. So, what was a workable structure they could have thought about that we could have adopted that was not so colonial as we have it today?
Yeah, so I recognize always my own limitations, and I don't have an original idea of my own in terms of what that alternative constitutional ethos should be today, let alone say what it should have been 75 years back. This is work that I hope to do going forward, and I hope that I can, with the help of other like-minded people, come up with ideas of this nature. I certainly will try, but there is no such idea in the book. But at that point of time, and this is why I think that we have the constitution we do, this was the tried and tested model. We needed consensus, and this was the consensus that we could have gotten. There was really only one alternative, and that alternative was the idea of a bottom up Gandhian constitution. Gandhi had wanted a constitution based on duties and not rights. Gandhi had wanted a constitution based on bottom up governance and not top down separation of powers. And it was a constitution that focused really on the moral uplift of individuals rather than their legal rights. Now, our training as constitutional lawyers I mean, it shows us that all of this is kind of extra constitutional. It doesn't seem like it's within the mold of constitutional law, which is why the framers of the constitution didn't take it up. There was much work to be done, and that work has not been done yet. So, because we don't know today, and this is work that I hope to do going forward, that how does an idea of duty fit in within the canon of rights? Okay, we know that rights and duties are dual core opposites, but the point is that how do we try and think of the idea of duty within a framework of rights? That's something to think about. Secondly, in terms of decentralized governance, how do we bring the government closer to the people? There is a sense, and all of us have this. I mean, I certainly don't want my local residents welfare association to have too many powers. Okay, I feel that, oh no, I would rather trust a unknown bureaucrat in the Delhi Municipal Corporation. But why is that? And I think there is a deep seated distrust that we have for local level leaders. Ye to local corporators, ye sab to good hai. There's this kind of uh, thinking that all that they're interested in is hafta, whatever, extortion. Now, the answer cannot be then take away power from local and give it to somewhere far away, because the answer really must be get better people. Okay, so I think as our democracy matures, I hope that we will be able to, and greater amounts of scholarship. And since you are your target audience for the podcast, and this video is a lot of law students, I would urge law students to look at issues in relation to duties, to look at issues in relation to decentralization, to look at issues that solve the problems of India. And I think once we start doing that, we will get to an alternative.
Yeah, I think that answers the next question I was going to ask, which is what should be the steps we take going forward. I think that answers a bit of it. Last term, I did this lecture on decolonizing the courts and the constitution, and I feel the colonial hangover still exists within our judicial institution as well. And I think it starts the moment you enter a courtroom. And literature points out that it's designed to intimidate. You're supposed to be intimidated because you're at the mercy of the judges. I think while we have very progressive rights in the constitution, that ambience hasn't changed, which makes it very daunting for a person to come to the court of law, which I also think are questions that we should think about: how architecture plays a role, how these things need to change, the attire and everything else. One of the reasons, as I write in my review, I think your book is extremely important because it raises several important questions. Questions like, why is our constitution not reflective of the values of a freedom struggle, like satyagraha, non-cooperation? Why is it so lengthy? Were the deliberations in the assembly truly democratic? And I wanted to touch upon some of these in the next few minutes that we have. So often the Constituent Assembly is hailed as this body that was truly democratic in the process of its constitution making. However, your book highlights that in many areas the body underperformed. Particular provisions like directive principles were not as discussed as they would have been. How do you elaborate on this claim of how democratic this body was?
No, I think democratic is an interesting expression because, as we know, the Constituent Assembly was not a directly elected body. The Constituent Assembly was indirectly elected by members of all the legislators in the provinces of British India, nominated members from the princely states. So, and after the Pakistan Constituent Assembly was created, you had about 90 princely state members and I think, about 200 odd members from British India. So, one is that we must realize that these are not elected legislators. Okay, so these are people who are seen by elected legislators as experts of something. So that's the first point that I think we need to recognize. The second is that practically many of them were also part of the cabinet, either at the center or at the states. So, for example, BGK. BGK was a member of the Constituent Assembly but was the premier in the state of Bombay, the chief minister of Bombay. Sardar Patel was home minister. Nehru was prime minister. You know, Shama Prasad Mukherjee was in the cabinet. So there were many people who were juggling roles. So they were actually spending most of their time in their day-to-day function. Now we all know that whatever is day-to-day tends to get priority, and whatever is something that needs to be done in 2 years' time gets put on the back burner. So the fact is that amongst the Constituent Assembly, a large number of members were holding critical executive positions, and so they may not have been able to give this as much time as was necessary. And the third point is that as a result, what happened is that a bulk of the heavy lifting was done by lawyers. First, it was done by B.N. Rao, the constitutional advisor, who has been given very little credit, but has done tremendous amount of work in getting a first draft of the constitution together. And then a lot of it was done by the drafting committee. And the drafting committee led by Ambedkar, but with Kanhaiya Lal Munshi, with T.T. Krishnamachari, Sadullah, Devi Prasad Khaitan, and there were all lawyers to begin with. Okay, and so the fact is that I think the constitution is a reflection of that. That the politicians were missing because they had more critical, pressing engagements. Number one. Two, it was an indirectly elected body, so it was not directly elected by the people. And three, it was a lot of lawyers, and so you tend to find a lot of cautious thinking that doesn't want to change from the status quo too much. And I think that's why we have the constitution that we do.
I think you mentioned B.N. Rao, and I agree with you that not a lot of people know about his efforts. And there's also S.N. Mukherjee, both of whom have been called by Ambedkar as the chief drafters of the constitution. But we see with, and I think that's a good thing about the book, that it highlights the stories of these unsung heroes that we've just forgotten of how important they are in our constitutional journey. But when we talk about the Constitution, it has automatically become synonymous with Dr. Ambedkar as the chief drafter. And you do touch upon it briefly. Why has he become the face of the Constitution? But would you elaborate on that? That what has resulted in us just identifying the Constitution with Dr. Ambedkar?
So first is that I'd like to point out that there's a beautiful book written by Arvind Ilangovan on B.N. Rao, which I think should be compulsory reading for anyone interested in constitutional history. There's a lot of great work that's been done by Arvind on this subject. And I think Ambedkar's influence has two facets. First is that Ambedkar really shepherds the constitution drafting process from September 1947 to about October 1948 when the first draft is presented, and then again in the last bit till November 1949. And there he does play a very critical role. He plays a very critical role as the chairperson of the drafting committee, making many calls, ensuring that there is consensus, speaking, almost having the last word on any article. Because whenever President Rajendra Prasad wanted to close out a debate, he always looked to Dr. Ambedkar. And Dr. Ambedkar actually had the last word on many of these provisions of the constitution which were being debated. So that is number one. And number two is that as in our politics over the course of the last 70 years has meant that there has been a sea change in the way in which Baba Sahib has been viewed. At the time when Baba Sahib became a member of the Constituent Assembly, he was a politician who had been brought in by the Congress party because he didn't win, he didn't get elected from the state of Bombay. He then went over to Bengal, where Jogendranath Mandal, another very fascinating leader who became the law minister of Pakistan first, but then was quite bitter about it. Jogendranath Mandal had given up a seat, but that seat went to Pakistan. So then Gandhi prevailed and on Rajendra Prasad and got Ambedkar in from the state of Bombay. So at that point of time, and this is no disrespect, but Ambedkar was not a mass leader as a politician. I mean, he had a very large and devoted following amongst the Dalit population, but was not a mass leader in the way in which we see it. And the reason is twofold. One is that Ambedkar wasn't liked by the communists. The communists really thought that issues around caste were petty bourgeois issues and they were taking away from the class struggle. So but now, of course, Ambedkar has become everybody's darling. And also, the views that Ambedkar had in relation to um, seeing Dalits as not part of mainstream Hindu society meant that the Ambedkar was also not liked at that point of time by the Rashtriya Swayam Sevak Sangh and the Hindu Mahasabha, both of whom thought that this was efforts at stratifying Hindu society. And this was, of course, as you know, the biggest point of disagreement between Ambedkar and Gandhi as well. So Ambedkar in his lifetime was a politician who was not a mass leader, but over time, as in has become someone who has been appropriated by all parties, and I think that what has happened as a result of that is that, and I think Ambedkar himself might have been fairly distraught that he has become a little bit of a holy cow, and it's not possible to have a discussion on his works without an allegation that you're disrespecting him. I hope to do that in my book by saying that I respect Baba Saheb wholly, and a lot of what he has done in the constitution is why uh, India is in such a great place today. But I think we can have an honest conversation about his writings and the constitution as well.
I think that's an interesting contradiction because, as your book points out, that Jawaharlal Nehru wanted Sir Ivor Jennings to head the
So
chairmanship of the
this
drafting
actually
committee.
does seem to be after I've written the book, and I have a couple of sources that I cited for this. But it's interesting you raise this because after I wrote this book, I was contacted by somebody who said that this is entirely not true.
Okay.
That Jawaharlal Nehru wrote to Ivor Jennings. Yeah, I wanted Ivor Jennings as the chairperson. So I went back up and looked at the sources. There are some secondary sources which do say it,
Okay.
uh, but I have not found a
Okay.
primary source. that
Okay.
says that. So I don't know whether Nehru wanted Ivor Jennings or not, but we can certainly say that Gandhi wanted Ambedkar.
Yeah.
That we can certainly.
Yeah, and I think the contradiction here is because Ambedkar himself did not want Indians to draft the constitution at one point of time. And as you write, he wanted a foreign jurist to head the technical commission. But I think another contradiction is that when we call Ambedkar as the architect of the Indian constitution, while on one hand we are hailing him with this title, but he himself later disavows his role in drafting the constitution and says, I was a hack, I did what I was asked to do, much against my will. And how do you perceive this contradiction with Ambedkar's, subsequent views on the constitution and saying, I just did what I was asked to do?
Yeah, see, I think that we shouldn't take statements out of context. I think we have to understand the context in which that statement was also made, and that statement was made post India becoming a republic. As in Ambedkar, in the last 5 years, and his writings clearly show it. As in, he was always a bit angry, but he also became a bit bitter, and you can see that bitterness in those writings. Uh, I think, and there were many reasons for that, and we don't need to get into that at this point of time. But the short point is that Ambedkar knew that he was doing a job, and he did the best job that he could do in the straitened circumstances that we were in. But does that mean that every word of that constitution is his? Not at all. Does it mean that every word of the constitution he would have to personally defend? Not at all. And that is why when Ambedkar was kept being asked about the constitution and why there was this provision, why there was that provision, he reacted in this manner. And so I actually don't see this as a contradiction. I actually see it as a fact that a constitution needs to change. And succeeding generations must change it. And sometimes changes may be something that we think is for the better, and sometimes they might be restrictive. But the fact is that I think Ambedkar realized that there were several aspects of the Constitution that perhaps took a view that the state would now turn around and become a guarantor of liberties for citizens. And he realized that that would not be the case so quickly, even though India was independent. And it's only 75 years that we have been independent. And I think we are in a pretty good place. We've done well. But we have to think for ourselves at every generation as to what constitution.
Yeah. So I just have like two quick final questions because I know we've been talking for a while. Uh, so one of the important questions you raise in the book is the role of Mahatma Gandhi. And our freedom struggle is considered synonymous with Mahatma Gandhi. Just like Ambedkar, he's also this holy figure that you have to, if you're in politics, you have to say you believe in Gandhiji. But we find that his twin mantras of non-violence and satyagraha both don't find a place in the constitution. And you've touched upon this in your book. How and why do you think those Gandhian principles are missing from the text of our constitution when we have some provisions that are not directly related to a constitutional structure also there? Why do you think that is?
See, I think because Gandhi himself is not interested in the constitution by the time 1946-47 come around. Gandhi is much more interested in the moral uplift of individuals. You see that his interest in the constitution is in Hind Swaraj, his early work in 1909. If you read the constructive program, which came out in the late 30s, which is sort of later Gandhian thinking on the subject, Gandhi is more interested in how we can ensure that we keep the country clean, how he's interested in making people educated. These are so he's kind of moved on away from constitutional questions. And because he's moved on from constitutional questions, these ideas of nonviolence and satyagraha, which are essentially about the moral uplift of individuals, are not seen as relevant to the constitution. They are seen as in a different plane. So Gandhi's plane is here in the realm of politics and personal upliftment, and the constitutional plane is here, which is primarily a plane of lawyers and judges and so on. So I think that's really the primary reason as to why this is missing. And the second, as I said earlier, is because, and Kanhaiya Lal Munshi says this, that, or maybe I'm making a mistake here, I'm sorry, I'm not sure who said this, but it was said that, the drafting committee didn't spend much time behind bars. So perhaps that is the perspective from which they came from. But I think that explains it, because I think
Yeah.
that the lawyers, as many lawyers were very much part of the freedom movement and spent time in prison, but most of the drafting committee, with the exception of Munshi, actually, was never spent a moment behind bars. And I think that that's one of the reasons as to why nonviolence and satyagraha, which are abiding parts of our freedom movement, don't find a place in the constitution. And Shruti Kapila has written something very interesting about this, that he finds that the constitution, in a review of Madhav Khosla's book, that the constitution and the freedom struggle seem like they are operating in different planes, and they kind of never
Mm.
intersect with each other. And that's something that I think future work can be done on.
Okay. Just my two final questions. One, what was the process of writing this book? And did you come up with certain revelations, certain unlearnings that you yourself did not know in the research, that you were very surprised by a finding that you did while in the particularly researching the book? For me, it was the entire chapter on how the Hindu Mahasabha and the RSS, they were drafting the constitution. That was as colonial as we have today. But were there certain revelations for you as well?
Yeah, so I think that the entire process of writing this book was a process of unlearning, because we have a way in which constitutional law is taught and a way in which we imbibe it. And I think that through the book, what I tried to do is think for myself about what I feel about the constitution, taking the best of what my teachers have to offer. And I think the constitution of the Hindustan Free State that you spoke about, which is the Hindu Mahasabha's constitution, was, I think, one piece of research that I'm happy about, because there's not much that's written about it. Partly because the Hindu Mahasabha was such a fringe player at that time. But Savarkar is not a fringe player in today's time. He's very important political actor, and someone that the BJP and the Sangh Parivar look up to. And I think it's imperative that we understand him a little better. And the constitution of the Hindustan Free State, which was drafted by the Hindu Mahasabha, is a reflection of that. It's a reflection of the fact that the Hindu Mahasabha also wanted India to be a secular state. It didn't want India to have a state religion. And it wanted everyone to have freedom of religion and minorities to protect their culture, language, and script. There's a lot to unpack there. We can do a different podcast on that. But I think it just shows that, we should avoid simplistic castigation. Uh, there, there might be a lot of things that we can criticize, but there are some things where we must call a spade a spade. And the constitution of the Hindustan Free State was certainly a secular constitution.
Certainly. My final question, Orgo, why should someone read the colonial constitution?
Because it's only 210 pages long. It's written in very simple English, and you can get through it in a flight on a flight. So that's why I think you should read it. But on a more serious note, I hope that you do read the book and think for yourself as to what you think about the Constitution. You did not agree with everything in the book, but if I can make you think, and you would like to think a little bit more deeply about the Constitution, then please do pick up a copy.
Thank you so much, Orgo, and I can vouch for it. You come out with a lot of answers, but you also are left with a lot of questions to think about later, which I think is a hallmark of great scholarship, which Orgo has always written. Thank you so much, Orgo, for speaking with me.
Thanks, Swapnil.
Hello, everyone. I hope you enjoyed that conversation. The idea behind the podcast is to spread awareness about the law in an engaging manner. I've done my part, and now you do yours by liking this video, sharing it, and subscribing to the channel so that you never miss out on more such conversation. Also, don't forget to let us know how you found the episode and if you have any suggestions for us by typing them out in the comments below. Thank you so much and stay tuned.